office in 2006, did we ever have an acting Chief Justice in the Philippines? We cannot afford to have an acting Chief Justice at this point in time when we are at the advent of what we call the automation of our elections.
Senator Drilon, for the negative side, you have 2.5 minutes to argue why there is no necessity to President Arroyo's appointing the next Chief Justice.
We submit that there is no necessity. First, the requirement that the vacancy must be filled within 90 days can be complied with by the new President, who will have 45 days from July 1 to August 17, 2010, within which to make the appointment of the next Chief Justice. Second, Section 12 of the Judiciary Act provides that, quote, in case of a vacancy in the office of the Chief Justice, the duties and powers of his office shall devolve upon the Associate Justice who is first in precedence until another Chief Justice is appointed and duly qualified. There is therefore no basis for the fear of a vacuum in the Supreme Court in case no appointment is made. The rule of succession has been consistently followed by the Supreme Court. Thus, on April 19, 1979, when the term of Chief Justice Fred Ruiz Castro ended, it was Justice Enrique Fernando who acted as Chief Justice until he was finally appointed as the regular Chief Justice on July 2, 1979, 2 months and 13 days after the vacancy was created. In the 1986 Constitutional Commission, the esteemed jurist Roberto Concepcion opined that in the event of the inability of the Chief Justice to act in any capacity or for any reason, including retirement, the most senior Associate Justice shall assume the post of acting Chief Justice of the Supreme Court. Thus, when Justice Amor Herrera retired on May 10, 1992, one day before the presidential election on May 11, 1992, it was the successor of President Cory Aquino, President Fidel Ramos, who filled the vacancy on August 10, 1992. The position was vacant for 90 days and the Supreme Court continued to function. Justice Ricardo Francisco retired on February 13, 1998 during the term of President Ramos. It was President Joseph Ejercito Estrada who appointed the replacement on September 13, 1998, or 223 days after the vacancy was created. The Supreme Court continued to function with only 14 members for 223 days. All these precedents will show that there is no need for an appointment by President Arroyo, since no vacuum or detriment to the public is caused by the retirement of Chief Justice Puno. The Supreme Court is a collegial body. It could very well function with only 14 members. In fact, 8 members of the court can decide the case.
Attorney Lambino, your question. Senator Drilon, 1 minute to answer.
Well, Senate President Drilon, isn't it a fact that the Chief Justice is the presiding officer of the Presidential Electoral Tribunal? And if we are going to have only an acting Chief Justice when the next president is going to assume office, and if and when there is a contentious issue pertaining to the legitimacy of the election of this new president, would it be possible that the acting Chief Justice may play politics in order that he is going to get the favor from the incumbent president or the next president?
Purely speculative. You trust that whoever is the acting Chief Justice will act in accordance with the law and his conscience. The Presidential Electoral Tribunal is composed of 15 members of the Supreme Court. The acting and with the absence of a regular Chief Justice, the acting Chief Justice is only one vote. Even assuming that he plays politics, he can be overruled by the 13 others. The Supreme Court and the Presidential Electoral Tribunal are collegial bodies. The acting Chief Justice has only one vote, and the 13 members can overrule him.
Yes, Attorney Prata.
Senate President Drilon, are you aware of Section 12 of the Judiciary Act of 1948, which has ensured that the succession in the event of retirement of the Chief Justice continues?
Yes, sir. In fact, I cited that in my short presentation, that Section 12 of the Judiciary Act reads, in case of vacancy in the office of the Chief Justice, the duties and powers of his office shall devolve upon the Associate Justice, who is first in precedence until another Chief Justice is appointed and duly qualified. And in a series of examples, the Supreme Court, in fact, or the most senior Supreme Court Justice assumed the position as acting Chief Justice without intervention from the President as a consequence of Section 12 of the Judiciary Act. The most recent example that I can think of is the time when the Chief Justice Fernan had to resign because he wanted to run. He ran for Vice President in 1992. It was acting Chief Justice Narvasa who assumed the position without any intervention from President Cory Aquino at that time.
Thank you, gentlemen. Now we move to the next aspect of the proposition that President Arroyo's appointing the next Supreme Court Chief Justice is beneficial. Attorney Drilon-Lambino for the affirmative side, 2.5 minutes, sir.
We cannot afford to leave a vacuum in the third highest position of the land. The Chief Justice is the head of the entire judiciary. The Chief Justice position is so important that we cannot have an acting Chief Justice to stay in office for a long period of time of at least 90 days or in fact 120 days. The Chief Justice is a very influential position. The provision of law that was cited by Senate President Drilon regarding the Judiciary Act of 1948 cannot apply in this particular case. Remember that during that time, the 1987 Constitution was not yet in place. The Judiciary Act of 1948 applies to a situation whereby the appointment of the members of the court, including that of the Chief Justice, passed through the Commission on Appointments. In this particular case, we have already a Judicial and Bar Council that vets the appointment to the Supreme Court. And once the appointees or the nominees are submitted by the Judicial and Bar Council, then the President must make the necessary appointments. It is beneficial to have a permanent Chief Justice because it is important that decisions to be made by the Supreme Court on constitutional matters should not be subjected to any pressure, more particularly if the case would involve that of the executive department. It is often said that when one is not given the security of tenure for the particular position that he is holding, he may be subjected to pressures from the appointing authority. And it is dangerous to have an acting Chief Justice who could be subjected to pressure from the appointing authority. More particularly so if there are important constitutional issues that would relate to the executive department. This is not something that we can just leave behind to the whoever is the next president to be elected. It is important that the Supreme Court should be complete with one permanent Chief Justice. And it is important to have the Chief Justice be independent from the appointing authority.
Senator Drilon, your question. Attorney Lambino, 1 minute to answer it.
Is Attorney Lambino aware that there were in fact instances under the present Constitution that the vacancy in the Supreme Court was not immediately filled up, and a period of time lapsed before an appointment was made. And in that period of time, the Supreme Court continued to function, even where the membership was less than 15, because precisely the Supreme Court is a collegial body where the absence of one or two or even three would not hamper the power and ability of the Supreme Court to decide cases, including when they constitute themselves as a presidential electoral tribunal.
Well, I am aware that the Supreme Court functions as a collegial body. Remember that there are only 15 members of the court, including the Chief Justice. As I said, when all of them retires at the same time or resign at the same time, and then we impose the ban as provided under Section 15, Article 7, which applies only to executive positions, then we will end up with no Supreme Court, with no justices of the Supreme Court that will decide the issue. Now, what the Senate President was citing are isolated instances when there is only one justice perhaps that has retired, and therefore the court can still function as a collegial body. But if we are going to apply the ban for the appointment of the Chief Justice or the appointment of the